Hi viewers, greetings of the day to all of you. We welcome you on behalf of NRI Legal Services. NRI Legal Services, as you know, is a global premier firm handling property issues of NRIs. It also is handling all the property issues as well as the allied issues of the NRIs, and we have been rendering this service from last 22 years. We have been holding Ask Me Anything sessions in the past also. Today we are back with another session of Ask Me Anything. In this session we'll discuss about the inheritance rights of NRIs. During this session I will be assisted by my colleague. Please introduce yourself.
Hello everyone, I'm Advocate Hasrat, Legal Associate at NRI Legal Services.
Thank you, Hasrat. So during this session, we'll be discussing about inheritance rights of NRIs. You're welcome to shoot your questions. It would be our endeavor to answer all the queries raised by you. We are here to handle all those queries. So first of all, let me tell you what is inheritance. Inheritance means when the property devolves upon a person. Property's title devolves, property's rights, liabilities devolve upon a person after the demise of another person. So inheritance and how the inheritance can take place. It is basically, it can be through the will or it can be through the intestate succession. When we talk about inheritance through will, it means testamentary succession. How the property devolves through will and what kind of property devolves through will. That is self-acquired property. It can be movable property also. Whereas through natural succession, it can be self-acquired property also, it can be ancestral property also. When we talk of ancestral property, there can't be will for inheriting ancestral property. Ancestral property devolves upon the family members by birth. When we talk about ancestral property devolving upon by birth, it means the daughters also have equal right. Any child born in the family gets the right of the over the ancestral property. And we'll continue with this discussion. And any question we received so far?
Yes sir, there's a question by Ms. Rajni Kumari. It says, I'm an OCI card holder settled in USA. My father owned agriculture land in India. My brother is holding the possession of this land. Can I inherit the agricultural land? Sir, can I please answer?
Please go ahead.
Thank you, Ms. Rajni, for your question. It is very clear from your question that this is a self-acquired property of your father. So you are a legal heir in this case. This means that you will get a proper share in this property. Since you are a part of the class 1 legal heir in your family along with your siblings and your mother, so you are capable of holding the proper share.
Okay. Let me clarify further, Ms. Rajni, this is pertaining to agriculture land. It is very clear that you can inherit the agriculture land in India, but you cannot buy agriculture land or any plantation property. NRIs are prohibited to buy the agriculture land as well as the plantation property. But as explained by Advocate Hasrat, in this case, you rather having a OCI card, but you will be entitled to have equal share irrespective of it being a agriculture land. Any other question?
Yes, sir, there's another question from Mr. Ayush Ranjan. He says, my friend's sister is living abroad and after the death of their father, she is seeking her share in the property of her father, which is presently in the possession of my friend and his mother. Is the sister of my friend entitled to any share in the property through inheritance? Sir, could you please clarify?
Okay, let me handle this question. Ayush, let me clarify to you that your father is no more and he has left property and your sister is claiming the property. You said she is claiming her share in the property. If your father has not left any will, then in that case your sister will be entitled to equal share in the property. She is one of the class 1 legal heirs. And if your father has left a will, then the property will devolve upon the people as per the wishes of your father. But in this case, as you said, your mother, yourself and your sister, there are 3 siblings left behind by your father. So you along with your sister and mother will be having 1/3 share each in the property. I hope it clarifies your question. Any other question?
Yes, sir. There's another question from Mr. Rahul Thakur. He says, मैं 2011 ਤੋਂ UK ਵਿੱਚ ਰਹਿੰਦਾ ਹਾਂ। ਮੇਰੇ ਪਾਪਾ ਨੇ ਮੇਰੀ ਮੰਮੀ ਦੀ ਡੈਥ ਤੋਂ ਬਾਅਦ 1997 ਵਿੱਚ ਦੂਸਰਾ ਵਿਆਹ ਕਰਾ ਲਿਆ ਸੀ। ਮੇਰੇ ਪਾਪਾ ਦਾ ਐਂਸੈਸਟਰਲ ਘਰ ਮੋਗੇ ਵਿੱਚ ਹੈ ਤੇ ਮੇਰੇ ਪਾਪਾ ਆਪਣੀ ਸੈਕੰਡ ਵਾਈਫ ਅਤੇ 2 ਬੇਟਿਆਂ ਨਾਲ ਉੱਥੇ ਰਹਿੰਦੇ ਨੇ। ਕੀ ਮੈਨੂੰ ਮੇਰਾ ਹਿੱਸਾ ਮਿਲੇਗਾ ਮੇਰੇ ਪਾਪਾ ਦੇ ਘਰ ਚੋਂ? ਥੈਂਕ ਯੂ ਮਿਸਟਰ ਰਾਹੁਲ ਫॉर योर ਕੁਐਸਚਨ। ਮੈਂ ਤੁਹਾਨੂੰ ਇਹ ਕਲੀਅਰ ਕਰਨਾ ਚਾਹੁੰਦੀ ਆ ਕਿ ਇਹ ਤੁਹਾਨੂੰ ਇਹਦੇ ਵਿੱਚ ਪੱਕਾ ਹਿੱਸਾ ਮਿਲੂਗਾ ਇੰਡੀਆ ਦੇ ਇਨਹੈਰੀਟੈਂਸ ਲਾਜ਼ ਦੇ ਅਕੋਰਡਿੰਗ। ਬੇਸ਼ੱਕ ਤੁਸੀਂ ਉਹਨਾਂ ਦੀ ਫਰਸਟ ਵਾਈਫ ਦੇ ਸਨ ਹੋ, ਬਟ ਫਿਰ ਵੀ ਤੁਹਾਡਾ ਤੇ ਉਹਨਾਂ ਦੀ ਸੈਕੰਡ ਵਾਈਫ ਦੇ ਸਨਸ ਦਾ ਇਕੁਅਲ ਰਾਈਟ ਹੋਊਗਾ ਤੇ ਤੁਹਾਨੂੰ ਇਹਦਾ ਹਿੱਸਾ ਕਲੇਮ ਕਰਨ ਤੋਂ ਕੋਈ ਨਹੀਂ ਰੋਕ ਸਕਦਾ। ਸੋ ਡੈਫੀਨੇਟਲੀ ਯੂ ਆਰ ਐਲੀਜੀਬਲ ਐਂਡ ਯੂ ਵਿਲ ਗੈਟ ਯੋਰ ਪ੍ਰੋਪਰ ਸ਼ੇਅਰ।
That's right, Hasrat. I hope it is clear. Any other question?
No sir, not yet. There's no question yet.
Okay, let me continue with that discussion of inheritance. What are the laws which are governing the inheritance of properties? The basic laws which are governing the inheritance by succession is Hindu Succession Act 1956. Hindu Succession Act 1956 is handling in succession of property in the case of Sikhs, it's handling Sikhs, Buddhists, Jains and Hindus. That is governed by Hindu Succession Act, whereas Indian Succession Act 1925 is handling the property inheritance by Christians and Parsis. Even testamentary succession of Hindus is governed by Indian Succession Act. And the properties of Muslim, the law which is governing that inheritance is the personal law of the Muslims. Furthermore, if we discuss that what are the rights of a girl child in the family, whether she gets inheritance by way of birth or not, I must clarify that prior to 2005, the girl child never had the right in the property, in the ancestral property. But after 2005, there has been amendment in the Succession Act, and it has been brought out that the girl child being a partner, she has equal right in the properties where she is born. Right? Any other question?
Yes sir, there's a question from Mr. Sunil Kumar. He asks that my NRI friend has been disowned by his father in India and given his property to his daughter. Being a class 1 legal heir, can he claim his share in the property? Sir, please share your views.
Okay. Mr. Sunil Kumar. So your NRI friend has been disowned by his father, and now whether he has share in the property being class 1 legal heir. Let me clarify here, Mr. Sunil, that your friend otherwise is entitled to the share even if he has been disowned by your father, because if it is ancestral property, then by birth he is having the right in that property irrespective of he having been disowned by his father. But so far as the self-acquired property of his father is concerned, on that property, if he may not have any right, if his father wants to devolve his property to any person or his daughter or wife, then he cannot claim any right over the property. However, if his father has not left any will, then he can put a claim over that property. So there is no law which is governing it, but in ancestral property definitely has a right, but in the self-acquired property, as I explained, he will not be having any right. I hope, Mr. Snail, it is clear. Any other question?
So there's another query from Mr. Amit Kumar. He says, my friend is an NRI. His parents are not alive and he's the only son. His grandfather expired recently, leaving commercial as well as residential property in India. As a grandson, does my friend have any right over the property of his grandfather? So I want you to answer this one.
Okay. Let me clarify, Mr. Amit, that directly the grandson does not have any right over the property of the grandfather if his father is alive. However, if the father is expired, as you have brought out that your father, your parents are not alive, so since parents are not alive, then to the extent of the share of the father, he will have the right over the grandfather's property, but that share cannot exceed the extent of the share of the father. I hope it is clear. Any other question?
So there's one more query from Mr. Harshnur Singh. He's asking, my friend's mother owns a flat in Delhi and has recently expired. Who are the legal heirs of my friend's mother's property? So please share.
Okay. Friend's mother owns a flat and has recently expired. Now your friend's mother has class 1 legal heirs, and those class 1 legal heirs are the husband and the children. The property will devolve equally upon the class 1 legal heirs, that is the husband and the children. In case she had made any will, then the property will go as per the will, otherwise it will be equally divided amongst the husband and the children. However, if there is some confusion about the partition of the property, because you said it is a flat, right? It's a flat in Delhi. So if in such case there can be amicable settlement arrived at by getting the valuation of the property done, and then the party who is having share, that can be compensated by the other party. However, if the partition cannot be done amicably, then it can even be got done through the court by filing a partition suit in the court of law. Then the court, after following due process of law, does the partition of the property if it is partitionable. Otherwise, court also appoints a court commissioner. Through the court commissioner, the value of the property is assessed and the entire money is distributed amongst the legal heirs in equal shares. I hope it is clear. Any other question?
So there's one question from Mr. Jassa Sidhu. He's asking, my friend and his family are NRIs presently settled in Dubai. We have ancestral property in India. My father's only brother is in possession of that property and has refused to give any share to my father. What can we do? So please explain this.
Okay, let me handle this question also. My father and his family are NRIs presently settled in Dubai. Let me clarify here that as also explained earlier, the ancestral property is a property where one acquires the right by birth. In this property, your father has right in the property by birth, and hence his brother cannot refuse or decline him his share. If in case the brother is declining share to his your father, then he can approach a court of law. Initially he can try to settle the issue amicably. If the brother doesn't agree, then he can approach the court of law and seek his share, being the ancestral property. And he will also have to prove that the property is ancestral. Only then he'll be able to get his share in the property. I hope this is clear, that your fathers can claim the share in the property being ancestral property. The brother cannot decline the share in the property to his brother. Any other question?
Yes sir, there's a question from Miss Heer Bajwa. She's asking, मैं कनाडा विच रहंदी हाँ, मेरे मम्मी और पापा दा घर लुधियाना विच है. ये घर मेरे पापा ने अपनी सेविंग्स तो खरीदिया सी. एक NRI होने दे बावजूद कि मैं अपने पापा दी प्रॉपर्टी इनहेरिट कर सकदी हां. So can I take this question?
Please carry on.
Thank you for your question, Miss Heer Bajwa. मैं थानू ये क्लीयर करना चाहती हाँ कि थोड़े क्वेश्चन तो ये चीज़ बहुत क्लीयर है कि ये घर थोड़े पापा ने अपनी आप दी सेविंग्स तो खरीदिया सी. इस दे मुताबिक वो ये घर किसी नू भी डिस्पोज कर सकते हैं. वो अपनी मर्जी नाल इस घर दी विल बना सकते हैं ते किसी नू भी दे सकते हैं. इन केस थोड़े पापा दी डेथ इंटरस्टेट हो जाती है, विच मीनस कि उन्होंने अपनी विल नहीं बनाई, फिर ये प्रॉपर्टी उन्हों दी थोड़े सारे फैमिली जेडे थोड़े फैमिली मैंबर्स उन्हों दे लीगल 1 क्लास हेयर्स ने, थोड़े सिबलिंग्स ते थोड़े मदर, उन्होंने विच इक्वली डिवाइड हो जाऊगी. तो इस गल तो कोई फर्क नहीं पैंदा कि तुसी कैनेडा विच रहिंदे हो. आई होप दिस आंसर्स योर क्वेश्चन.
तो मिस हीर बाजवा, आई थिंक बिल्कुल क्लीयर है थानू कि ये प्रॉपर्टी थोड़ा पूरा हक बनता है. मैं भी क्लैरिफाई करना चाहता हूँ कि सारे NRIs किते भी रहते होन आउटसाइड इंडिया, लेकिन उन्होंने प्रॉपर्टी फोर फादर्स की प्रॉपर्टी अगर इंडिया दे विच है तो उन्हों का उस प्रॉपर्टी ते बराबर का हिस्सा बनता है ਡਿਪੈਂਡਿੰਗ ਅਪੋਨ ਕਿ ਉਹਨਾਂ ਨੇ ਕਿ ਰਿਲੇਸ਼ਨਸ ਹੈਗੇ ਆ, ਫਾਦਰ ਦੀ ਪ੍ਰਾਪਰਟੀ ਜਾਂ ਪੇਰੈਂਟਸ ਦੀ ਪ੍ਰਾਪਰਟੀ ਜਾਂ ਗ੍ਰੈਂਡਫਾਦਰ ਦੀ ਪ੍ਰਾਪਰਟੀ, ਉਹਨਾਂ ਵਿੱਚ ਉਹਨਾਂ ਦਾ ਬਰਾਬਰ ਦਾ ਹਿੱਸਾ ਬਣਦਾ ਹੈ ਤੇ ਉਹ ਆਪਣਾ ਹਿੱਸਾ ਕਲੇਮ ਕਰ ਸਕਦੇ ਹਨ। Any other question come?
Yes, so there's a question from Miss Iknoor Sandhu. She's asking, my father purchased a residential property in India in 1980 and soon after our family moved to UK. My brother moved back to India along with my mother in 1996 and has possession of the property ever since. He is disagreeing to divide the equal shares of the property between all our siblings. What are my inheritance rights?
Okay,
Sir,
please
can I
handle,
take this?
please
Yes.
handle this question.
Thank you for your question, Miss Iknoor Sandhu. I would like to make this clear that this is your father's self-acquired property. So either he makes a will or if he dies intestate, then this property is divided amongst all the legal heirs. Since your brother is in possession of the property, you have to approach your brother and ask for your proper share in the property. In case he is refusing to part with your share of the property, then you can definitely file a suit against your brother in the court of law, and that is how you will get your share in the property.
Okay, I hope it is clear. And then you can claim the share by filing an appropriate suit. It can be suit for declaration, wherein you can ask declaring the court, seeking declaration from the court that the property belongs to you. Then you can seek partition of the property also through the court. Then you can seek possession of the property through the court, and even injunction can be sought through the court that in the meanwhile, when the suit is pending before the court of law, your relatives cannot dispose of the property, or they cannot alienate the property or create any third party rights in the property. So you can claim your property, your share through the court of law also by filing these type of suits. Any other question?
Yes, sir, there's a question from Miss Afreen Khan.
Okay.
She's asking, one of my friends is an NRI from UK. His father was living in a live-in relationship with his mother and never got married. Having been born out of a said live-in relationship, does my friend have right over the property of my father? So please share.
Okay. Child born out of the live-in relationship. Let me clarify that there is no law laid down under any succession act governing the inheritance by the child born through the live-in relationship. However, the Honorable Supreme Court in 2008 has clearly brought out that if a child is born to a couple who is in a live-in relationship, that child will have the inheritance right over the property of the parents to whom it is born. So your friend, being a child born out of the live-in relationship, will have the right over the property of his parents. But let me also clarify that he will not have any right over the ancestral property. Secondly, Supreme Court has also clarified in 2015 that when a couple is living in a live-in relationship for a long time, then that couple is considered to be a married couple. So their marriage may not be otherwise held, but as per the law laid down by the Supreme Court, they are considered to be married couple. Notwithstanding that, as I explained to you, that you will be having, your friend will be having a right in the property of his parents, even if he is born from the live-in relationship. I hope it is clear. Afrin, any other question?
So there's one more question from Mr. Divjot Chadda. He's asking, my father is a co-owner in an ancestral property. He has made a will pertaining to the ancestral property, bequeathing his share in the name of my brother. What are my inheritance rights? So please explain this query.
Okay. If father is a co-owner in ancestral property and he has made a will pertaining to the ancestral property and giving it to one of your brothers. Let me clarify that. First of all, it is ancestral property. Your father is not competent to make a will of the ancestral property, as I explained earlier also. So if he has made such a will, that will is challengeable, and that property which has been given to your brother by way of will, that can be challenged, because ancestral property, he does not get the entire right over the property. Whatever property he has inherited and being ancestral property, it goes to every member of the family, of his family, in equal shares. So he could not have made a will of the ancestral property, so he cannot give that property to one brother or one child, so you can claim that property by challenging it in the court of law. Okay, any other question?
No sir, we don't
Okay.
have any questions yet.
Okay, let me clarify here further on that the rights of a wife by way of inheritance. Can the wife inherit a property of her husband, or how she inherits the property? Let me clarify here that a wife inherits the property of her husband only, but she cannot inherit the property of she cannot inherit the ancestral property of her in-laws. Ancestral property cannot be inherited by a daughter-in-law. It goes only to the husband or his siblings, and whatever share comes to the husband, then the wife, being class 1 legal heir of the husband, she can inherit that property through husband, because that property then becomes his self-acquired property. Moreover, a wife can also inherit property, maybe ancestral property of her parents, because she, being a class 1 legal heir of her parents by birth, she acquires the right in the property of her parents, in the ancestral property of her parents. But so far as self-acquired property is concerned, she cannot claim any right over the self-acquired property. Self-acquired property, either it goes as per the wishes of the parents, they can make any will of the property, or even if the parents expire without making any will, then she will get equal share in the property with the other siblings. So those are the rights of the wife over the ancestral property or self-acquired property. Any other question?
So there's a question from Mr. Ramandeep.
Okay.
He is saying, I am an NRI from India. I purchased a house in Surat which is presently occupied by my wife. The house was registered in her name. She has divorced me and remarried. When I asked her to vacate my house, she clearly refused. How can I get back my property for which I had spent so much money? Sir, can I take this question?
Yeah, please.
Thank you for your question, Mr. Ramandeep. It is very clear from your query that the house is registered in your ex-wife's name. So clearly you don't have any legal rights to get back the house. The only way how you can get back the house is by entering into a settlement with your wife. Although you may have spent all the money in getting the property, but still that does not make you the owner of the property, because it is registered in her name. So the only way to get back your property is getting into an out-of-court settlement, and that is also only at the discretion of your ex-wife. I hope this is clear.
Okay, so it is advisable that when you spend your hard-earned money, so that should be property should be purchased either in joint name or in single name, maybe the person who is spending the money, because subsequently it becomes very difficult, especially for the NRIs, to get back that property from their siblings or from their spouse, etc. So spend your hard-earned money well thought of. Okay, any other question?
No sir, not
Okay.
yet.
Furtherance to this, I will also clarify regarding the inheritance rights of a adopted son. An adopted son is like a natural son in the family by the family which has adopted him. So the adopted child will have equal right in the property of the family by the parents who have adopted him. He will have equal right in the property of the parents in the adopted family. But so far as his biological family is concerned, he will not have any right in the biological family, because he swears all his rights from the biological family. He will only get the rights in the family by which has adopted this child. So I think any other question? There is no question.
Sir, not yet.
Let me also clarify that whenever the NRIs are abroad, and mostly they are, and they have inherited property, so they should not hesitate in approaching the concerned, in approaching the court of law or in approaching a best property law firm to know that what are their rights in that property. Even the due diligence of the property can be done by the NRIs, So they should not just close their eyes and then they should just go ahead whenever they come to know that there is some property which has been left in India by their forefathers, because their inheritance rights never die even if they have shifted abroad. The inheritance rights will always continue, and as soon as they come to know that the inheritance, as per the inheritance laws, the property has to be inherited by them, then that can be claimed by various ways and means. One of the way, as we discussed, is through the court of law, and there are other ways like getting it amicably settled. So it is our sincere advice to all the NRIs that they should keep a track of the properties of their forefathers, and because they have the right over the properties and they inherit those properties very well even if they are sitting abroad. With this we'll come to the end of our session, and in case anyone has any further queries on this issue, you're most welcome to ask those queries. Even you can send those queries to us on our website, that is query@nrilegalservices.com. You're most welcome to put your questions. In case we have not been able to take up any question during this session, we'll reply to those questions separately and we'll come back to you. Thank you so much, and please stay safe and stay healthy.
Thank you.
Thank you. Thank you, Astrid.